Welcome to the Generous Benefits Podcast, where we help employers create meaningful, people-first benefits that make a real impact. I'm your host, Amanda Brummitt. Today, we're joined by Sarah Borders, a compliance consultant with Benefits Compliance Solutions. Sarah guides employers on a wide variety of compliance tips, including COBRA, ACA, ERISA, HIPAA, and the new fiduciary expectations under the Consolidated Appropriations Act, our topic for today. If you're a CFO, HR leader, plan fiduciary, this one's for you. Sarah, thank you so much for being here. I really appreciate your time and always fun to have a fellow Texan on the show. I gave people a little bit of who you are in the intro, but can you tell us in your own words, who are you personally and professionally?
Yeah, it's great to be on your show. So I am a longtime veteran of the benefits industry. Started in the benefits world back in 2006 in Corpus Christi, Texas. Was the place that was hiring to find someone to pack boxes for their office move. So the broker that I worked for, they were moving offices and they needed to find someone to pack all these boxes up and
Literally.
Yes. And so I was willing to do whatever they asked me to do. They said specifically, this is a temporary position. And so I said, you know what, I'm going to do a really good job. I'm going to show up. I'm going to dress up for work because that's kind of how my parents taught me is dress for the job you want.
Yep.
And after a few weeks of packing boxes, I said, I can answer the phone. And then it was, I can run quotes with carriers, and they taught me how to do that. And before I knew it, I was an account manager working for that same broker. So I was an account manager for them and other agencies throughout Texas over the course of about probably 10, 11 years. So around that time, towards the end of my account management career was when the ACA really came into law, and it very much began to change our industry. Employers specifically had to do ACA reporting.
ACA being Affordable Care Act.
Yes. So Obamacare, this big law that was passed in 2010 began to apply to employers in their day-to-day work. And so they needed people to kind of step up, explain these things to employers. And so that is when I really transitioned from account management to compliance consulting. And from there, worked for a large national broker in the compliance department, and we started our firm, Benefits Compliance Solutions, in 2019. And so my husband and I own this consulting firm, and we help currently agents and agencies to essentially act as their embedded compliance department. So that's been a successful model, and here we are today, 6.5 years later, running strong.
Yeah, Sarah, that's wild. In like 15 years, you went from the person packing up the office to one of the go-to people in the industry for benefits compliance.
I know. Strange, right?
Well,
Didn't know what was in store for me, but it's turned out to be a great industry. And I would love to see more young people join our industry because it's a great career to have.
yeah, I totally agree. Well, let's start with definitions because I feel like compliance is sort of an alphabet soup. In just plain language, what is fiduciary duty for health plans under the Consolidated Appropriation Acts, and who holds that duty?
Yeah, great question. So if we kind of look at fiduciary, what is a fiduciary? It's really someone who has oversight and has a heightened level of oversight on the plan itself. And so when we talk about fiduciary duties for health and welfare plans, so we're talking about, I don't want to get too technical here, but health and welfare really relates to health insurance, health benefits that employers are providing. So when we're talking about health insurance benefits, then we're talking about the responsibility to act in a certain way when you are an overseer of that particular plan. So if we think back to before the Consolidated Appropriations Act was passed in 2021, about 10 years before that, there was this fiduciary duty oversight, so to speak, that's required for retirement plans. And so what the CAA really did CAA being, of course, for short for that piece of legislation, is it really kind of brought forward those same retirement plan duties for health and welfare plans similarly. So those rules weren't necessarily, new as a result of the CAA. They were just brought forth into the forefront to place the same importance on them as they were in the past for retirement plans. So with it, yes, did come with it a couple of additional compliance requirements, but it really just heightened the scrutiny that the government was going to place on overseeing the plan carefully, being a prudent fiduciary, so to speak. So what is a fiduciary specifically? So under the CAA, plan fiduciaries are expected to ensure that they make these health plan decisions like selecting vendors, working with their broker or advisor in a specific way, paying fees that are reasonable, approving their contracts much more prudently than ever before. So employers can no longer be a passive participant. They have to be an active participant now in the way that their plan runs. And so some employers are thinking maybe, well, who exactly is a fiduciary? Is it someone that is called? Is that a title? Is that something that, my boss tells me I am? And really, it's very simple. It can be a title or, a name that's given, a legal fiduciary, but it's really anyone that has, I would say, direct oversight of the plans, how the plan pays benefits. So if there is an individual within an organization, HR leader, perhaps CFO completely, they absolutely make those types of decisions to work with this vendor, work with this broker, pay these claims, hire this pharmacy benefit manager or PBM. So they're fiduciaries just by way of their position, by their authority to make these decisions. So that can be a surprise to employers who really don't even know that they're fiduciaries. They're acting as a fiduciary, and they can be personally named in a lawsuit. So with that type of responsibility comes with it a lot of, duties or requirements that need to be met overall.
Yeah. Thank you so much for making the link to retirement. I am familiar with the CAA and fiduciary duty, and I've always thought, gosh, that sounds so ERISA-like. And now you finally closed that loop for me. I understand why it's so similar since it's an extension of retirement plans. And so, is the Enron scandal? Would that be a classic example of poor fiduciary?
Possibly having to do, and my area of expertise is really over on the health plan side of things. But right, with the idea of fiduciary oversight of their retirement plan or pension funds, that's where really the scrutiny was placed in the past, is on, investments that are made with employees' money and even the employer's funds. This is very tangled up into these funds. So yes, there's extreme scrutiny as a result of things like that. Pension funds that went bankrupt. Really, pension is where this whole ERISA law even originated from, was because pension funds were not carefully managed and went bankrupt, and people could not access their pensions. So it's evolved over the years into kind of where the abuse has taken place, or neglect, or just people running it that had no business running it, weren't informed of these things. So you can see now that in the course of business, it has become squarely more affected on group health insurance plans, because a lot of them are self-funded and they have to be managed. They have to have this oversight, just like a pension fund.
Right. So on the health side, like the Johnson & Johnson lawsuit, is that under the CAA?
Yes. So that lawsuit was a landmark case, because if I can say it in non-legal, sort of layman's terms, essentially the reason that was such a landmark case was because the plaintiff brought that case with kind of the claim was against the fiduciaries for making the plan too expensive because they weren't scrutinizing their pharmacy costs, essentially. I mean, that's a very broad overstatement of it, but that's quite different than some of the other fiduciary failures that you see. This had to do with how much the plan costs,
Mm.
and that the plaintiff felt that if you had better oversight and your pharmacy costs were more controlled or more in line with maybe benchmarks or how much it costs at the actual pharmacy, it wouldn't blow up the cost of the whole plan and therefore to the premiums that employees pay. So it kind of opened this door, even though that case was dismissed, it kind of opened the door for, another way for plaintiffs' attorneys to come in and find fault or failures because they're not scrutinizing their plans. And Johnson & Johnson would be one that should, that absolutely would be able to. So it really did kind of change the conversation with what employers need to be doing and paying attention to, even for smaller employers than Johnson & Johnson.
Yeah. So what are those things that they need to be paying attention to and doing to truly be a good fiduciary of the plan and the plan assets?
Yeah, so there are a few core actions, core responsibilities that every plan sponsor, and when I use the term plan sponsor, it's an employer who is sponsoring a plan. These are these terms that you hear quite a bit. They're in the regulations. The DOL uses them. So I'm going to use that term plan sponsor. Just know it's an employer.
Yeah.
So first and foremost, especially if you are self-funded plan, meaning you have a TPA that is managing claims, you have stop loss to cap the level of liability that your plan is going to incur. You hire a pharmacy benefit manager to process pharmacy claims, whether that's with the TPA or apart from them. If you're an unbundled, self-funded plan, this is where I really feel as though you need to be super careful. Number one thing you should do is review your vendor contracts and fees. So under the CAA, one thing that was brought about that is very similar to a retirement plan is this idea of compensation disclosures from really the broker or consultant.
Yeah, which isn't new.
No,
People
it's not.
weren't doing.
Right. Weren't doing it in the past, at least for health and welfare benefits. So this was new under the CAA, this particular requirement. And so what employers should be looking for, they should, if they're not receiving it, they should be requesting it. The burden is on the employer to actually request it, not the broker or consultant. Now, good brokers and consultants should be supplying that just, automatically. But if you are not, or they are not, and you have not seen anything, you should be requesting that because, again, that's part of your fiduciary duty is to examine these compensation disclosures. But what that was designed to do was really to document that they have received them, that they are understanding their costs, their fees, their commission structures, and what are you getting as a result of that payment. So it doesn't mean that it has to be the cheapest option. Not at all does it mean that. It just means that they need to be able to create the value. The value is there for working with this particular consultant for that fee. It has to be reasonable. So requesting those, examining them, reviewing them, and then, of course, keeping things on file. You're going to hear me say a lot of that. So that's number one. Access to claims and pricing data is also something that's a little bit different, especially if you're going from fully insured to self-funded. With fully insured plan, it's nearly impossible to get the claims data. Not in every state, but in some states, it is, very, very difficult to get that claims data. So, but when we're talking mostly about fiduciary duty, looking at self-funded plans, you should be able to understand, can I access my claims data, the pricing data, costs, claims costs themselves, maybe de-identified, utilization, network discounts, network utilization, adequacy, that type of thing, rebates for pharmacy spend. So they should be able to pull that data and examine it for themselves. And they're allowed to do that under many different rules. HIPAA is not one. That's a lot of times what people think, well, I can't under HIPAA. Yes, you can.
Yeah, that's an excuse.
That's an excuse. You can absolutely see your claims data if you are managing a covered entity, which is the group health plan itself. So that's another thing, kind of the second thing to ensure that you are meeting is your claims costs, your fees, and et cetera. Also, the fiduciary governance piece. This could mean formalizing a health plan or fiduciary committee. You hear sometimes about chartering a fiduciary committee, and in the past, retirement plans did have fiduciary committees that would meet periodically to, review plan assets, ensure that their service providers were on point, just meeting regularly to be able to show and demonstrate that there was this oversight taking place with a group of individuals who were, knowledgeable about plan benefits. They were knowledgeable about their fiduciary duty in the first place. So that could be one way to meet the duty. It's not required, meaning ERISA doesn't say, yes, you have to have a fiduciary committee, but being able to show governance and prudency would be ideal to have a committee set up and documenting those minutes, emails and other communications, RFPs, et cetera. And then the last thing, certainly not the only thing, but generally speaking, you want to stay current on just day-to-day compliance deliverables, those that came as a result of the CAA, such as RxDC submissions. Those are due by June 1st each year. Submitting your gag clause attestations by December 31st. And then ongoing requirements such as ACA reporting or, your 1095Cs, those types of things. Staying in compliance with federal rules is part of being a compliant plan fiduciary. So staying on top of just compliance to-dos overall, that's going to take you further than most employers, just being able to document all of those items.
So Sarah, what I'm hearing are the days of being passive and, oh, my broker's got it. Those are over. You have to be actively engaged in the purchasing decision, the why, documenting it. How do employers evaluate those vendors and confirm they're getting the right data and transparent fees? Like, even if they are engaged, how do they know if they're getting it right?
Right. So baby steps, I would say. When an employer is taking control of the cost conversation and looking again to primarily go to a self-funded model, then there's certain things that they can do right away when vetting these vendors to manage their claims, these TPAs and so forth that their broker are bringing to them. So where I would say, and I don't see this very often, but it's easy to do it, you want to make sure that you're going to be able to get access to the plan data and these transparent and reasonable fees. At least you can tell. So I think becoming an informed buyer for health insurance starts with asking the TPAs that are being sent the RFPs for quotes. That's part of it. But having calls with them if you feel like, hey, this TPA is really seems like a good fit for us. The pricing is reasonable. It's within our budget for what we want to accomplish. Ask them some questions before you sign the contract with them. Are we going to be able to access our data? First and foremost, you can ask them that, and you should, because you should not assume that they will just give it over. Some are absolutely doing well with that. Some will not give it to you. And there's many reasons as to why that might be. But I think the more independent the TPA is, meaning they're not also acting as a large carrier, there's self-funded versions of fully insured plans. They're going to be a lot less likely to just hand over your claims data than maybe a more independent TPA would, because they are more objective and they don't have their networks and their contracts and so forth. So using a more objective and independent TPA is probably step one. That's not always the best idea, but asking the question, can we access our data? And if you can't, then why not? Why can't we have it? And see what they say. What's the reasoning for that? And I would also say once you have their fees, you see what your broker commissions are going to be, what your broker is receiving in commissions, and any other sort of fees for pharmacy benefit management. you want to benchmark that across market norms. There's some ways, some advisors can provide that information. Maybe the more sophisticated ones have analytics departments, or you can simply engage a third-party analytics vendor that can, scrutinize the fees and the claims cost overall and benchmark it against sort of the market forces. So, that may be year 2 or 3 where that's implemented, but, you certainly can ask those questions in the forefront before you even move forward. I would also say some things that are easily discoverable would be identifying any conflicts of interest. So one of the fiduciary duties is to avoid conflicts of interest. Some of these are more obvious than others, but you want to ask, again, this is all about sort of interviewing vendors and even advisors before you start working with them. Ask them if they receive compensation from the carriers, the pharmacy benefit managers, or any other third parties. Like, where are their incentives coming from? Now, it's one thing for commissions to be paid for, medical insurance. Sometimes that's not even an option, but that shouldn't be the reason why that particular advisor places business is because their commission structured better for them, obviously.
Right.
They work for the client, not for the carrier. So that conflict of interest can be picked apart. Is it your family member that owns this company and that's why you're working with them? Stuff is a little more obvious, but you want to identify any conflicts of interest because that can be fodder for potential lawsuits or an investigation. And the last thing is that employers should really implement on an ongoing basis is to negotiate the terms. So pushing back, you have the right to push back, just like with any other contract, on any clauses that are questionable, and especially ones that limit data access or don't give transparency. You're not allowed to, by law, have these gag clauses in your contracts. And so if you see one or your lawyer sees one, this is a good use of a lawyer. Why is that there? We want that removed and we want to access our data. And if they won't remove it, you should not work with them. You should work with someone else. If they won't negotiate those terms, you should not be working with them because you could get in big trouble if you don't. So those are some kind of preliminary things, it just seems so obvious and kind of common sense. But act like this is your house and kind of, you're going from renting a house with a fully insured plan to owning a house with a self-insured plan. You have to become an informed consumer, and your job as a fiduciary, it sits in your lap. You are the one who's holding the bag for this. So hopefully that kind of outlines some steps that you can take as a fiduciary.
Yeah, I think it's a really, really, really good outline of that. And I would add that even though it is the employer's responsibility, that their broker should be actively engaged in bending over backwards to help them get access to all this. And if their broker isn't advocating on their behalf, they need to find a different broker. Or if they get squirrely about talking about their fees, or this should be a very transparent process. And if it's anything but that, run.
Right. Yes. And there are amazing, advisors and brokers out there that absolutely hold their feet to the fire. They work very hard on behalf of their employer clients. They bring to the table solutions. They disclose their fees openly, or if they're getting commissions, which again, sometimes you don't have an option not to receive commissions in certain instances. And that should be fine as long as they're doing the work that you all decided upon and the value is there, that you can reasonably say, yes, they are providing so much value that this other one that may be a little cheaper doesn't provide or doesn't help me with what I need to comply with. So you're absolutely right.
Yeah. And then, Sarah, what are those things that need to be in the file to prove that you've been prudent as a purchaser?
Yeah. So all about document. A paper trail should exist. And so if the Department of Labor, as they often do, wants to investigate a health plan, they will send a list of documents that they want to see. Number one, plan document. You should have a plan document and you should do what it says. That again is another fiduciary duty that some people don't really know is there. But yeah, you should know your plan exists and follow it, follow the terms of that plan, eligibility and those types of things. Also, If a plaintiff's attorney files a lawsuit, which again is going to become more and more common and will go down market as time progresses, unfortunately, then that clear defense is going to be shown in that paper trail. So if you can document meeting minutes, committee meeting minutes, if you can form and charter an ERISA fiduciary committee, you should show who's attended, what was discussed, what decisions were made. Decisions to stay with a particular vendor should be outlined as to why that happened. There should be that scrutiny in writing. Any sort of fee disclosures or analysis for those advisors, brokers, TPAs, pharmacy benefit managers. TPA stands for third party administrator, by the way, sort of a claims administrator, processor. Those types of fees should be listed usually in a spreadsheet against other fees that may be available, and documenting maybe why this one was less expensive or more expensive, why you went with them or did not go with them. Just sort of documenting what's discussed in these meetings. And with AI, you can have these notes taken for you with a note taker app and just keep that in your files about what was discussed without having to do a lot more work. Everything we do should be able to be recorded. And honestly, if there's something that you shouldn't be saying in a recording, you should probably not talk about it there or whatever. But overall, you want to document these discussions and these conversations, these decisions accurately, RFPs and vendor comparisons, and then, of course, documenting any compliance deliverables like your mental health parity, non-quantitative treatment limitation, NQTL analysis. You should have a copy of that if you can get it. And any RxDC filings. These are specific filings that are due June 1st, I think I mentioned previously, that are supposed to go to the government so that they can, report to Congress on claims costs and so forth. And then any sort of other documentation like your COBRA processes, your compliance with the Affordable Care Act, your filings, just overall documents about what you're doing as far as being in compliance. Plan document again, cafeteria plan. Those types of things can go a long way when you're having to demonstrate that you did, in fact, have a prudent process in place, that you monitored your service providers, that you did not have any conflicts of interest, or if you did, you got rid of them, that you've reviewed your contracts, that your fees that you're paying are reasonable, and that any sort of complaints or employee type complaints, you can say, no, in our plan document, it says this, all those types of common sense activities that you would be doing if it were your own house, for example.
Yeah. And they are so common sense. And they do, as you're talking about it, feels like things we should be doing for normal due diligence. But something about documenting that process really shows intent to comply with the law, which I think matters in the case of it going to court. Showing that you intended to comply with the rules helps a lot.
Right. And just because something's really expensive does not mean you're automatically failing on your fiduciary duties. Again, it's all about what is the market saying as compared to it, and can you reasonably sort of defend the reason that you chose to go with the higher cost or the fees that are structured this way. So
yeah. And Sarah, do these rules apply to all employers, regardless of size, regardless of funding source, or are there specifics around that?
So ERISA applies to pretty much all employers except for, and this is regardless of size or funding strategy, it applies to all employers, both private sector and nonprofits. It does not apply to governmental plans, church plans, actual church plans, or to Indian tribal plans. So that's really it. If you're very small and you're in the public sector or nonprofit, you're subject to ERISA. So yes, the fiduciary duties do apply to mostly all employers. Again, if you're not subject to ERISA, then not necessarily, although state laws sometimes have similar types of rules. But overall, most employers, fully insured, small group, large group, self-funded for sure, have they do have fiduciary duties. Now, with fully insured plans, it's a little bit more limited to be able to examine these costs, but they still can certainly ask for data. They can document that they've reviewed fees and quotes and made those determinations. So don't forget about those who are fully insured. You still have requirements, but maybe it doesn't make sense to have claims analytics or charter a fiduciary committee if you can't even really see a lot of your data. You can see maybe, aggregate type claims and things like that. So it does apply to most employers.
Sure. Okay, that's a great explanation. And then last question, just you've shared so much good information. Is there anything else that you would want employers to know as they're thinking about this?
I think most employers, when they hear about this, are surprised. Maybe not so much because they've run retirement plans before. So I would say don't become alarmed or don't sort of feel like you can't do anything about this now. It's just too much work. Instead, I would take baby steps to start. If you're an HR professional or leader of HR, I would inform your CFO, your controller, kind of that risk individual within your organization. Hey, are we managing our fiduciary duty? And kind of have this conversation and begin to document it. And again, make yourself this informed consumer for your company and understand that you personally, again, could be named in a lawsuit. I don't say that to scare you. I say that to help you understand the severity of this particular rule and this standard that you have to meet. And if maybe this isn't for you, you might want to have that discussion with your leadership that I'm a fiduciary in this capacity. Maybe this should be taken on by someone else, or we should get fiduciary insurance to make sure that we're covered. So yeah, just kind of coming to terms with that, understanding that this probably does apply to you. Most people want to say, that doesn't apply to me. My broker didn't tell me that, or I'm too small, or I'm not in that role, or no one told me that. Question that and get serious about it, because it does and it can come up, and it will as time goes on. I would just kind of give you the truth about the situation.
Well, thank you for that. Thank you for making a very complicated topic way less complicated, very digestible, and just appreciate your time.
Thank you so much for having me.
Huge thanks to Sarah Borders for turning a dense topic into a practical roadmap. Thank you for listening to the Generous Benefits Podcast, where we keep it practical, personal, and people first.